Justice of the Appellate Division 4th Department. Hear ye, hear ye, hear ye. All prisoners have the message before the court is on here to be attended and shall be heard.
Good morning, please be seated. First case for argument is 941, People v. Taylor.
Good morning. May it please the court, John Sarando for the appellant. This is an appeal from a conviction for the crimes of robbery and murder. The first issue we'd like to discuss this morning concerns the amendment of the indictment. The indictment indicated that 2 shots were fired. After the close of proof, the people sought to amend the indictment to 3 shots. As this court said in Powell many years ago, it's not necessary to put such specific information into the indictment, but they did, and by doing so, we submit that they expanded the theory of the case and changed how the crime occurred. It was not simply a matter of form, and something like that should have been attempted prior to trial.
Counsel, did changing from 2 shots to 3 shots change the theory of the prosecution?
It did in a sense, Your Honor, because the 2 star witnesses swore up and down that there were only 2 shots fired. So if there were really 3 shots fired, you'd have to wonder, were they really there?
Doesn't that somewhat help the defense, however?
Yes, but then the court, it helps the defense in a sense, but then the court allowed the people to show that there were 3. I mean, that's something that should have been done, I think, prior to trial, so it doesn't sort of surprise the defense counsel. In addition, there's an ante marchi question insofar as when that occurred, because counsel indicated that the defendant was not present at the sidebar when that occurred. And as the court can see from the transcript, the defendant was somewhat of a vocal individual in court. And when he learned of that, it's apparent that he said something about it to the court. And that's when I think defense counsel indicated that he wasn't present at the sidebar. Another issue I'd like to discuss is the grand jury. 7 of us weren't there at some point or another. Obviously, the ADA did not follow the Collier rule of only vote if you hear all of the, quote, essential and critical evidence. The trial court went into an analysis. However, we submit their analysis fell short because he never analyzed all 23 grand jurors, who was present, who was not present, and who was present when they voted, and which ones abstained. You don't know if the ones who abstained were the ones who weren't present. So we submit that a further review is necessary, even to the sense of a remand back to the trial court to determine which of the 7 and what they did, because we know they weren't there. I think we've covered sufficiency and weight in our brief adequately. The severance issue, these were 2 separate criminal transactions. Apparently, they tried to use the robbery to show the identity of the murderer. However, their witnesses indicated that they knew who, the witnesses to the murder allegedly knew who the
Did the trial
shooter.
court ever issue a decision on the motion for severance?
No, it didn't. No, it didn't. And insofar as the other identification was, while the witness knew the individual, knew the young man, knew the defendant, it was undisputed that the police officer said that he pointed to the picture of the Taylor boy that was in the array. So we submit, when all of that is considered, that there should be a new trial.
Thank you, Mr. Sarando.
Thank you.
Morning, Your Honor. Brad Osler for the people. May it please the court. I first note that with respect to the amendment of the indictment, that was an unpreserved argument. Not only just unpreserved, but I believe defense counsel actually, trial counsel actually consented to the amendment. And I think the more relevant issue anyway is the fact that the amendment in this respect was not a change in the theory. It was simply to reflect the evidence of the medical examiner that the victim suffered from 3 gunshot wounds, the last one being a grazed wound. But that's not something that's in any way surprised or prejudiced the defense. The evidence was provided in the form of discovery prior to the trial and is not something that was particularly relevant to the actual trial defense. With respect to the Antomarchi issue, I don't think the record makes it very clear that the defendant was not actually present at the bench, but even taking defense counsel's somewhat equivocal assertion that he may not have been there, that's a purely legal discussion, and defendant's particular knowledge of the facts is not something that's going to inform the court with respect to whether or not the amendment could be amended in such a way. I just briefly reiterate, I think our argument with respect to the severance, that the court was without authority to sever the counts. The proof of the robbery, especially with respect to how the police identified the defendant, is part and parcel of the proof of the murder, and those counts were appropriately joined.
The court never issued a decision on that motion, and there was never any kind of further request to have the court render a decision.
I don't disagree with that, and I think it's somewhat complicated by the fact that it's not a motion. I think that the court actually had authority to grant. And then finally, with respect to the grand jury sufficiency, at least as far as the number of jurors, as the court noted, there were 7 abstentions and 7 grand jurors who indicated they were not present for all of the critical evidence and testimony. And the court actually undertook a sufficient inquiry that did not simply kind of make a decision in passing. It reviewed the record, it talked to the stenographer, it reviewed the information that a grand juror actually specifically provided about that particular issue, and that grand juror indicated that those that voted had been present for all of the testimony, and I think that's sufficient on this record to affirm. Thank you.
Thank you. Case 942, 943, People versus Witherow.
Good morning, Your Honors. May it please the court. I would like to briefly address point 3 of my brief. Under Penal Law Section 6027(5)(a), restitution is limited to the maximum of $15,000 except for 2 categories under subsection B. The first is return of the victim's property, including money or the equivalent value, and the second is reimbursement for medical expenses actually incurred. Wages do not fall under either category. In preparing for oral argument, I tried to wrap my head around the people's contention that wages fell under the exception for victim's property. So I looked up the definition of property and wages in the dictionary. Property is defined as, quote, something owned or possessed specifically, the exclusive right to possess, enjoy, and dispose of a thing, or something to which a person has a legal title. Wages.
Your point is that the wages weren't, yeah, they weren't earned. They aren't money or property that, that the victim had at the time, so they don't fall within the definition under the statute.
Correct. I think that this conclusion would be, under the circumstances of this case, being that they are very tragic. But I do think that the court is constrained to that interpretation based on what the legislature has done in this circumstance and not included wages in
Right,
the
and if the
exception.
victim seeks lost wages or pain and suffering, the victim can sue civilly.
Right,
And they have res judicata, the guy's already admitted the assault, and that's the avenue for those damages. Restitution in criminal is more limited. What about the waiver of the right to appeal? Is that a problem here for us?
I think that because I think that there's two ways you can look at it. The first is that it's an illegal sentence to order him to pay the wages. And the second one is that the restitution was not part of the terms of the plea agreement.
Yeah, you
So
can't
it-
waive something that hasn't taken place yet when it's outside the bounds of the statute.
Right.
It sort of falls back into illegality also, or that it's, not within the amount that you can recover per the statute.
Right,
Yep.
thank you.
Good morning, may it please the court. Chris Eagleson for the respondent. Regarding the waiver of appeal, it appears to me that the trial judge in this case did an exemplary job. He didn't conflate the issues, and he very clearly explained to the defendant those issues that he would be waiving if he were to waive.
So let's assume we agree with you that the waiver is valid. There wasn't any sort of discussion about kind of what the parameters of what the restitution might be. So it seems to me that that the restitution order wouldn't be covered in the waiver of the appeal.
I agree, Your Honor, and I conceded that point in my brief. I think that survives, so the issue of the sentence, of course, I believe does not. As to that issue regarding the restitution order, there is no disagreement that lost wages can be included in criminal restitution. I believe that was conceded by appellate counsel in this case. So we begin the analysis with the understanding that they can be included. The only issue to be determined is whether they are covered under the exception to the $15,000.
In excess of $15,000, whether lost wages can be covered when you're awarding restitution over $15,000, right?
Absolutely, Judge. That's, I think, the surviving issue on that matter. And I have to be honest, when I first read counsel's brief and started to contemplate this, I actually contemplated whether or not we should be conceding this point, because it seems to be a very strong argument. In the end, I didn't, and here's why. I think that in this case, there's basically two ways of looking at it. There's the terms of the statute itself, and I believe that with no case law in point, and I'm not trying to suggest that this is something that has never been decided. I simply couldn't find something on point, and I don't believe counsel could either. Hopefully, perhaps this court can. But with nothing on point.
Maybe it hasn't happened before for good reason.
I'm sorry, Your Honor?
Maybe it hasn't happened before for good reason.
Yes, maybe we reached so far, nobody's ever done it before. It seems unlikely to me, but who knows? It just, in this case, if it hasn't been decided, I think that one of the things we look to is the legislative intent. And I think if we look to that, the whole idea is to make the victim whole and to hold the defendant accountable for his misdeeds.
Well, when you look at the legislative intent, right after subsection 5B, subsection 6 in the statute says that any payment for restitution doesn't foreclose a civil action for an amount, that's not covered by this statute. So, and as Justice Lindley said, this lost wages seems to be more appropriate for a civil action.
Well, certainly future lost wages, and this man's never going to work again. So that could very likely happen.
But why draw the line between wages, lost wages up until sentencing, and lost wages for life? It's under your definition, your broad definition of property, which includes money. I would think we wouldn't stop there. We would look at his life expectancy, earning expectancy, and award the victim that amount.
Would that we could, Your Honor, but we can't. I think the case law is very clear that the clock stops at the sentencing. So what we determine restitution in a criminal context is for out-of-pocket losses, and that is defined by its
So you're
terms.
making a distinction between that they.
I'm sorry, Your Honor.
The point you're making is that the lost wages have come and have gone up to that point. And
Yes, Your
so
Honor.
therefore it's property.
Yes, Your Honor.
But, something in the future is not.
Correct,
Let me
Your
bring
Honor.
you back to you had said the legislative intent. Couldn't we just look at the statute, and I think that's what opposing counsel's point is, and look at the plain meaning of what property means, and why would we have to go look at the legislative intent of what says what it says?
Because I think, Your Honor, that in this case, under these facts, as we apply them to that statute, I think that it could be, and it's certainly worth consideration given the facts, it could be that this, when they talk about the loss of property, that it
No,
could.
they don't talk about the loss of property, they talk about the return of property. That's, I guess, the problem I have with the statute. It talks about the return of property, which seems to presume that something was taken from the victim.
And that was the key word when I was looking at this. We're presuming something, right? If we're going to presume in one way, shouldn't we contemplate a presumption in the other way? In other words, it's not so clear on its face that it disposes of this issue. We have to make certain presumptions, certain leaps. And I think that if we're going to do that, we have to then look at the legislative intent, which
Okay.
should include
But
this.
maybe I posed it, maybe there's a better way of posing it. Your point is that they were earned and lost, these wages, and therefore it is property.
At the time of the restitution hearing, yes, Your Honor, that is what we're saying. Yeah, we do
Okay.
believe it should fall within that first subsection.
Okay, thank you.
Thank you.
Case 944, People versus Harris.
Good morning. May it please the court, Carolyn Walter Ford to Shambe Harris. In this trial, nearly a third of the witnesses were called to give testimony about Mr. Harris's actions in connection with an unrelated arrest over 3 years earlier. And this evidence had no probative value to the charges here. Admitting it was highly prejudicial, and it deprived Mr. Harris of his right to a fair trial.
Your argument is that it was classic propensity evidence.
That's precisely right, Your
The
Honor.
court felt that it was somehow relevant to the defendant's consciousness of guilt
Yes, and
in this particular DWI charge.
Yes, and I think that the critical difference here is perhaps Mr. Harris's actions on the night of his arrest for these charges could be relevant for that purpose. But his actions
3 years
three and a
earlier.
half years earlier,
Right,
Couldn't have been.
it's tough to say that something you do before you commit the crime evidence your consciousness of guilt for a crime that hasn't been committed yet.
yes. I
It's
think
like
that-
almost logically impossible.
I completely agree. And I don't believe that this evidence was admissible under any other theory. It was far more prejudicial than probative. And I think that the court's own remarks really show the prejudice here.
Can I just clarify one thing?
Certainly.
What would seem to be highly prejudicial to me, aside from the evidence itself, was they got in the fact that he was previously convicted of DWI, this
Yes.
being a felony. Was that, this is a felony, so there obviously was a prior one. Was there a stipulation that the jury, that precluded the jury from hearing about the prior DWI conviction? But for this evidence, this Molyneux evidence, would the jury have known of the prior DWI?
To be honest, Your Honor, I don't recall whether that issue was addressed separate and apart from the Molyneux evidence. I recall it
I
being.
got the idea that the defendant, as they were wont to do, will stipulate to that element so that the jury doesn't hear about it. That was my understanding of what happened here, but I wasn't 100% sure on it. Because if If that's the case, then it was all the more prejudicial. It wasn't just that he had faked these seizures and so forth, but it gets that prior conviction before the jury that
Yes.
otherwise would not have been there.
And to be frank, Your Honor, I don't recall to the extent whether that issue was dealt with separate and apart from the Molyneux issue. My recollection is that it was fairly intertwined, but Your Honor may be correct about that. I just don't specifically recall. And if I may, the extent of the evidence here really, although the court did give limiting instructions, the extent of this evidence really overwhelmed the intent of these curative instructions. This was, I think, the classic trial within a trial that the Court of Appeals and other courts have cautioned against. And finally, if I could just briefly note, I don't believe this error was harmless. I don't believe that the evidence here rises to the level of overwhelming. This is a case that relied heavily on the observations of various witnesses. There were inconsistencies there, I think particularly with respect to the timing of my client's seizure symptoms. When those happened, was that before or after he was restrained?
Could it be, is it possible for it to be harmless with respect to reckless driving, unlawful fleeing from the police officer, operating a vehicle not equipped with the ignition interlock? Those seem to be truly overwhelming evidence, unrelated to this Molyneux evidence. And could we parse it out that way and say it wasn't overwhelming on intoxication because it might have been impaired? There's a very thin line between impaired and it's clearly overwhelming that he was impaired to some degree by alcohol or drugs. But on the other three, could we do that and say overwhelming on these three, new trial on DWI?
I think the difficulty with that is that this evidence sort of pervaded the entire trial, and so I think it's difficult to parse out the effect that it may have had on the DWI conviction versus the others. Because of course, it's not just that the evidence was overwhelming, it has to have a reasonable likelihood of having affected the verdict. And so I think with respect to that prong, I think it's very difficult to separate that out. This was evidence that I think
So you think a new trial, if we find it not to be harmless, you think the defendant should get a trial on everything, a new trial on everything?
If the court is inclined to send it back rather than dismissing the indictment, then yes, I think that would encompass everything. We would ask this court to consider dismissing the indictment, particularly given that my client had served his sentence, the incarceration portion of his sentence at the time my brief was filed. If there are no further questions, I'll otherwise rest on my brief.
Thank you.
Thank you.
Morning,
morning,
Dan
Mr.
Gross for
Gross.
the People. The main issue in this case, like it is in many, if not all, DWI refusals, is the defendant's intoxication. And here, in order to hinder that investigation into his intoxication, he faked a medical episode, as found by the doctor who diagnosed him with malingering, which was a fairly rare diagnosis.
Which he had done before, and that was the Molyneux evidence that was admitted. How is that not classic propensity evidence?
Well, the judge made that distinction in his ruling. It was only provisionally admitted. However, it was dependent on what the argument was going to be from defense counsel. And when defense counsel, through her cross-examination of the doctor, and I believe one of the police officers began to suggest that there was an innocent explanation and that this was truly a medical episode, that's when the door was opened to introducing this this previous arrest where the same incident occurred.
Right, but it sounds like the argument was, the rationale was, he faked it before, faked seizures before to get out of field sobriety tests, try to get out of a DWI. Therefore, he's faking it this time to get out. That's propensity. Now, it sounds, because look, the fact that he was faking it this time, there's plenty of evidence that he was faking it this time without the Molyneux, and that's consciousness of guilt. I think as counsel conceded. I just don't know as though on the theory that was relied on, whether we can use evidence that happened before a crime to say it exhibits consciousness of guilt.
Well, Judge, again, to your point, I would agree with your analysis. However, when defense counsel began suggesting to the jury that this was a seizure, they even went so far as to call a witness to say this was a seizure. Doctor, have you seen his previous medical records where he's received this treatment? Then I think that changed the tone and tenor of the case. I apologize for my mask slipping. And in that case, the door was open. I know this is more of a Molyneux claim than a door opening claim, but that had the danger of misleading the jury into thinking that this defendant had
It sounds
suffered
like
a
you're
seizure.
saying there's an alternative ground to affirm, that it's not consciousness of guilt. It's just relevant to show he's faking now.
Because he faked it before.
Because he has faked it before, and again, they were suggesting that there was an innocent explanation for this medical diagnosis. The only reason, and again, the legislators enshrined this in the DWI instructions, when a defendant has refused the chemical test, you are free to infer that they are afraid it would show their intoxication. Here, we had more than that. We didn't just have the chemical test, we had the field sobriety testing, where the defendant tried to get out of that by, again, I hate to use the word faking, but the doctor said he was faking this seizure, and again, had previously, then when there was a suggestion that there was an innocent explanation, he was receiving seizure medication, then it became, it needed to be brought out at trial that this had happened before. This pretty much exact same thing had happened before, albeit a different medical episode. So that is kind of the wrinkle to this case, because again, I agree with you. If you just brought in that he had done this a million times before, or even once before, then yeah, that would be propensity evidence. But again, once the suggestion was made to the jury that this defendant was actually suffering medical distress, then the people were allowed to apply to the court to present this evidence. Again, I touched on the permissive inference, and regarding your question as to whether this could be split, I'm not aware of that remedy, but I would suggest that it was harmless based on the remaining evidence, the reckless driving, the traditional indicia of intoxication, the refusal.
I agree on all those. I agree, overwhelming would have no effect on those. The difference, when you have no chemical tests, no field sobriety tests, no blood tests.
Sure.
He doesn't take any field sobriety. It's, the difference between impaired and intoxication is so minimal that it's tough for me to say it had no effect on that determination.
Again, I agree with you, and I would suggest to you that's why the legislators sought to remedy that by not rewarding defendants who refuse just the chemical test or even go out of their way to refuse all the field sobriety tests. Again, we're not interested, the government is not interested in presenting the refusal. They want the results of the refusal. So when a defendant attempts to sidestep that by faking medical distress, a permissive inference is allowable, and particularly where they try to suggest there was an innocent explanation for the dearth or the lack of evidence, then again, the same rationale should apply, and it should apply in this case. Absent any other questions, I'll rely on my brief. Thank you for your time.
Thank you. 9:45, People versus Ringrose.
Out on this one?
Yeah.
Justice Winslow is recused.
Good morning. May it please the court. As the people concede,
Yeah, you don't even have any opposition here today, do
Well,
you?
Yeah.
Your day in the sun.
this happens rarely, but I don't count anything until it happens, because obviously the court may have questions, but this case, as the people concede, is covered by People versus Fugazzotto. The plea was induced by a promise of concurrent time with the
Yep, not sure he would have taken it, but for, yep, I got it.
Unless there are any
Your heavy
questions.
lift was on the prior appeal.
Pardon me?
Your heavy lift was on the prior appeal.
That's correct. When the prior appeal resulted in the dismissal of six counts and a drastic reduction in sentence, the promise that was made to induce this plea could not be fulfilled, and therefore this plea must be vacated and back to square one.
Exactly. We got it.
Unless there are any questions, thank you, Your Honor.
Thank you. 947, Beck versus the City of Niagara Falls.
Good morning, Your Honors. May it please the Court, Corey Weber on behalf of the Niagara Falls Water Board. Your Honors, this case comes down to the simple threshold question of whether there was any duty owed by the Niagara Falls Water Board. The evidence that we presented at the trial court level established that the Water Board does not own the property, they didn't occupy the property, they didn't control or maintain the property. There was testimony
I think it's uncontested that there's no ownership or occupancy. I think the question comes down to control and special use, right?
Correct.
Particularly special use.
Correct.
And I think the argument is that the Niagara Falls Water Board's ownership of the assets below the road created a duty to maintain the roadway over those assets in safe condition.
So I think there was two parts of special use that were advanced. One was, does special use of the water boxes or the drains create a special use? And what we pointed out is that the case law is clear that when you have a special use based on a fixture installed in a roadway, your obligation is to maintain that location where you're actually deriving the special use. Right. You don't assume a duty to maintain the entire roadway.
Yeah, and so you know what, I thought about that, but this is how I've reconciled it in my brain. If you had a right-of-way and the defect was within the right-of-way, then you have an interest in the property, and there's probably a duty that flows to maintain that portion that you're exercising the right-of-way. But the question here is, did they make special use, or did you make special use of the part of the road where the plaintiff was injured? So if it was above where the grates were, or where the right-of-way is, and perhaps you dug a hole to fix something below where the drains are, and then you left it in a bad condition, you wouldn't need they wouldn't need special use. You have an interest in the property, and you therefore have some duty and obligations. As I see it, what they're trying to do is suggest that some area beyond the right-of-way and try to marry it to this special use. And I guess it's for us to decide whether or not, with what the Water Authority has done here, did they make a special use out of the part of the road where the plaintiff was injured? And your point is, no way.
Exactly, Your Honor. The structures were not at that location, and you don't have to take our word on that.
Yeah.
The plaintiffs represented that to the court early on when they petitioned the court for leave to serve a late claim on us.
Because there's no proof your client did anything to any part of this, whether it was the right-of-way or the other paved area.
Correct.
Prior to this accident.
Correct, yes. The testimony from the Water Board and all of the witnesses was the Water Board hadn't performed any work. So this case is distinguishable from the Ingram case that the plaintiff cited, where the defendant, their conduit was actually under the road where the accident happened, and they actually performed work at that site. Here, the structure isn't at the location, and they haven't performed any work. So there's no special use created by having the structure located some distance away. And just touching briefly on the second point, because we also raised actually 3 more independent grounds for dismissal. I'll just touch on the second point, the lack of creation of the hazard and the lack of notice of any hazard. As I just mentioned, the Water Board hadn't performed any work at this site, so they certainly didn't create the condition, and I don't even think there was a contention raised that they did. And there was also testimony that no one ever complained to the Water Board about this condition. So on creation and actual notice, I don't even think those points are contested, and summary judgment should have been granted. On constructive notice, what we pointed out was there's a question about what this condition actually is. The plaintiff testified that he couldn't describe it, he couldn't estimate the size. He acknowledged he never actually saw the condition that actually caused the incident, and conceded that the forklift may have actually hit debris instead of a depression in the road. So there's no description of a condition to say that it was visible and apparent. The plaintiff didn't even see it when the accident happened. And because he didn't see the condition and acknowledged it might have been debris and not a depression, there also can be no proof to show when that condition formed or developed on the property. So on creation, actual notice, and constructive notice, they provided another independent grounds for dismissal. And with that, I'll rest on our brief for the other arguments unless there are questions.
Thank you.
Thank you, Your Honor.
Good morning.
Good morning, Your Honor. May it please the court, Carrie Beyer, representing the plaintiffs back. I'd like to touch on something that Mr. Weber said at the beginning of his argument, that the ultimate question on this motion is a question of duty. What duty did the Water Board have in relation to Simmons Avenue in Niagara Falls? And I need to point to this court's decision in Romano v. County of Monroe, because that's where this court defined what the duty of a public utility is in relation to a use of the road. According to this court, as a utility making special use of a public way, the utility had a duty to use reasonable care to prevent its use from adversely affecting the public road. This duty includes ensuring that its assets did not contribute to a dangerous condition in the road, as well as keeping the valves and covers themselves in good condition.
So what is the special use of the road? What is the special use of the road?
Your Honor, the special use of the road would be using the road to house its water drains, its manhole covers, its sewer main, and its water main below the road.
Okay, so if the accident happened there, okay, then they would have a duty.
Yes, that is true, Your Honor. And I would like to point out...
This accident didn't happen there, though.
It didn't happen near the drains. It did happen near the manhole, Judge.
I'm sure.
It did not happen near the drains, but it did happen near the manhole cover, which was another Water Board asset located in the center of the road, which had also collapsed and been covered over by millings prior to the accident.
But your theory was that he hit a pothole, right?
That's correct, Judge, yes. And the representation that Mr. Weber points...
But is there any proof that it was near or at the manhole?
Yes, Judge. There was a map submitted by the Water Board in discovery that showed the location of its assets, including the drains to the west of the accident site and the manhole cover in the vicinity of the site. When you take that and compare it to overhead map photographs that were given to the witnesses during depositions, and in particular, the map marked by Tim Kowalik, the NMCC employee, where the accident occurred. He actually drew and initialed on the map where it occurred. It's in the vicinity of the manhole cover.
Let me ask you an unrelated question. Oh, no, actually, it's a related question. Doesn't the doctrine of special use require that that special use be unrelated to the public use, to the public purpose?
Generally, it does, Judge. That's true, but it's also been recognized that utilities use is for their own benefit. So the fact that it's a public utility that generally benefits the public doesn't make that the public's use of the road. The public is not installing drains and sewer systems and water mains underneath the roads. That's the Water Board's private assets. And in fact, prior to 2003, it was the city's assets. The reason the Water Board's in this case, I might point out, is that when we did move to serve a late notice of claim on the city pointed at the Water Board. So we're dealing with a situation at the trial court where the city's pointing at the Water Board because we are alleging, I think on substantial proof, that the drainage was inadequate and not working at the time, and that's what created these conditions. City points at the Water Board. Now the Water Board's trying to get out, saying that, well, hang on, this is not our purview, which would leave a pitfall of liability for plaintiffs, and I don't think that's the intention of the law. I believe the creation of the Water Board under statute was supposed to streamline the process of management of water-related assets in the city. It wasn't to protect the city from liability and give plaintiffs no recourse against the Water Board because it would have to be a special use.
Was there a right-of-way for the manhole?
Yes, Judge. It was.
You're saying that there's proof on this record that this individual fell at the manhole?
I believe so, Judge. When you compare the marked map.
Why would you avail yourself of the special use doctrine? If there's a right-of-way, then you have some interest in a property that would require you keep maintaining.
Judge, I think that we've availed ourselves of two separate theories here. Control and special use are separate. They're similar. I recognize that. When it comes to assets that the water board owns, I think that's a straight control argument. And I think that was submitted under the testimony of Mr. Eagler and Mr. Smeal from the city. When Mr. Eagler was the one, I believe, who testified that the water board had a right of way to access its assets in this area. That would include the manhole cover. Mr. Smeal, who is the city's foreman of roads, is the one who testified that they had control over this section of Simmons Avenue because they could enter the property, repair the property, cut the road without the city's permission because they could access to their assets. So I think it's both, Judge. I don't think we limited ourselves only to special use. I think that it's both of those theories.
So are you saying that we know that the contention was that it's the pothole that directly caused the injury, but your contention is that the pothole came to be because of the billings on the manhole cover and the inadequate drainage system?
Yes, Judge. I believe that there is proof in this record that due to the entire lack of proper water drainage on this road, due to the water board's wholesale negligence in repair and maintenance of its assets, that's what created these potholes. This is a gravel road. It is inherently less stable than a normal asphalt or concrete roadway. So the fact that...
Well, listen, you're losing me. Was the pothole right in the area where the right-of-way was, in other words, where the manhole cover was, or is the pothole somewhere else, not on the right-of-way?
I believe it was in the vicinity, Judge. I can't say for certain it was directly on.
That's not answering the question, in the vicinity. See, there's a difference in my mind, because I can't see how you could create a special use on land that's not within the right-of-way because water flowed over it into the drain. That doesn't make sense to me, but if the accident and the dangerous condition existed right in the right-of-way, then that I think you may have at least an argument there's a duty without availing yourself of the special use doctrine.
I would say two things to that, Judge. One, the question would be, how far does the right-of-way extend? Is it only over, say, an aerial view where you could take someone on a crane and drop them on top of the road? Is it only at that point where the manhole cover would break the surface of the pavement? Or is it an access to the road? The same way as if I built a house behind another property, I would have a right-of-way to build a driveway to access that property. It's the entire access stretch for which I would have a responsibility as a right-of-way. Here, I'd say the water board.
No, usually right-of-ways are defined by meets and bounds.
Mm-hmm. And second,
otherwise,
Judge,
on occasion, what we call shotgun easements, and then they're created by the use. But is your argument, is this on this record, because to be frank with you, I don't recall seeing that. Is there a defined meets and bounds description of the right-of-way?
I'm not sure that there is here, Judge, no.
Okay.
Which was why I would then rely on a second argument, which is to go back to this court's decision in Romano. Romano involved an electric utility that had shut-off valves in a road and had steel plates on top of those shut-off valves. Similar to the case here, the public road had become degraded. There were potholes in the road, and it just so happened that the electrical valve covers were at the bottom of those potholes. This court acknowledged that the duty to repair, the duty to maintain, extended just beyond those shut-off valves themselves to the surrounding area of the road, to the extent that the manhole or the drains physically collapsed underneath this gravel roadway and created a depression underneath the gravel, which then would have displaced additional gravel.
In Romano, the utility had done work in the area where the accident occurred. Isn't that correct?
I believe that's the Ingram case, Judge, which we also rely on.
Right.
In the Romano case, I don't recall if repair work had been done, but here, again, we also have, for control purposes, subsequent remedial measures. That the water board could access this property. It could repair these assets without the city's permission. And they did in 2015, approximately a year after the accident. Yeah. So there is evidence for control, and there is evidence for special use. And again, we're dealing with summary judgment here. In the light most favorable to the plaintiffs, this testimony, these maps, these markings, it's a question of fact that should be meted out by a jury. And if the city of Niagara Falls will go up into trial and blame the water board, it is only fair and just that the plaintiffs are allowed to have the water board represented at that trial. so that it will be for a jury to decide whether it was the city's negligence or the water board's negligence in failing to maintain these drains and failing to maintain this section of Simmons Avenue. Touching briefly on Mr. Weber's secondary points about being able to prove the cause of the accident, I think that the record has overwhelming evidence that this area of Simmons Avenue was in terrible repair, consistently covered with dangerous potholes. That comes from the plaintiff himself at his 50H. At his deposition, there was no change of story. He always said that he knew it dropped into a pothole. He heard the loud bang. He saw the forklift drop. I believe Mr. Weber is misrepresenting the plaintiff's testimony in this regard. And even if the plaintiff hadn't made those identifying statements, we have the testimony of Mr. Kowalik, who came out immediately after.
A similar argument that was made in the prior appeal.
Exactly right. Yeah, we do have one prior appeal. We have 2 more coming up in January.
Oh, yay, good.
So I'll be back up here. So to those points, especially on constructive notice, I think there are certainly questions of fact on those points, and it was properly denied. So thank you.
Thank you. 948, Worme versus Bannis.
Wipe that down for you.
Oh, thank you.
Thank you so much. Good morning, Your Honors. May it please the Court. Nicholas D'Angelo on behalf of the appellant. Your Honors, today I'm going to focus on 2 points of the appellant's brief, the standing issue, and then the very unique issue of the acknowledgement of paternity. At the trial court level, the appellant made 2 arguments on behalf of standing for the non-biological father, my client. The first was under Domestic Relations Law, Section 70. Now, our argument for that was based entirely on the Court of Appeals' decision in Brooke v. Elizabeth. Now, although not...
Why don't we go there then, okay, to Brooke. In Brooke, there was a much more formalized idea of what the parenting situation was going to be like post-birth than here.
Absolutely, Judge. There's no doubt about that, and we have not stated otherwise. There was no preconception agreement in the case at bar here, and also this is not a same-sex couple, so the Brooke decision is not strictly applicable. However...
You're saying that in Brooke, the door was left open for whether or not standing could be found in a case where there wasn't an agreement.
Judge, that's absolutely correct. And not only was it left open, it was deliberately left open by the Court of Appeals. There's a quote that was cited in my brief where the Court of Appeals specifically foreshadowed this case, a heterosexual couple without a preconception agreement. The court stated that they would decide that case on another day upon a different set of facts. And it's our argument that this is that other day, and this is that other set of facts.
So to that end, why don't you talk to us about how the petitioner is a de facto parent? Isn't that a major argument that you make, that he in fact was a de facto parent?
Yes, Judge, and that was laid out at the trial court level throughout testimony on numerous days.
Okay, so the things that I wrote down, some of the things that I thought, were your major arguments, including the fact that he watched the child at times, okay? Babysat even a couple of overnights for a period of time. So he provided some child care is what I'm trying to say, okay? The mother allowed the child to call him daddy, but the proof was she allowed the child to call lots of folks daddy, right?
Judge, both of those points are absolutely correct, and not to be minimized whatsoever. That was what the mother testified to during the trial. However, it is much more than that.
Yeah, why don't you tell us what more?
Absolutely. Judge, my client was the only father figure that the child had throughout her life between 2016 and 2019. Consistency is key with respect to that. Not only was he babysitting the child, that was a term that the mother used, that she looked at my client as a babysitter, but that wasn't what her own family testified my client's relationship was with the child. It wasn't what my client testified to his relationship being with the child. Not only that, Your Honor, my client had a room at his house for this child, fully furnished.
that the child spent multiple nights in per week for a significant amount of time. Now, not to get away from the fact that there was a period of time, as I'm sure Your Honor was going to point out, that the mother tried to sever that relationship prior to ultimately it being severed in May of 2019. However, at that point in time, her own family, her mother, her sisters.
That's a double-edged sword, too, what her family's role is in this.
It absolutely is, Judge, and it's not to be minimized, but it really goes to the monumental nature of this relationship between the child and the father.
Let's use your word, monumental. Is that, do you really think that this is a monumental relationship? I mean, even if you just looked at it in terms of time spent with the child, it certainly doesn't seem to be monumental in terms of time. So, I mean, they took some minimal steps towards adoption that didn't go anywhere, because she didn't want it to happen.
And Judge, that is absolutely correct. They did start the adoption proceeding and then it ended. But to get back to your question about the monumental nature of it, my opinion really is insignificant as far as if it was a monumental relationship. All I can tell you is that at the trial court level, the child was afforded an attorney. And that attorney at the trial court level consistently, throughout the entire 8 months that we were in Supreme Court, advocated at every single turn for my client to have access with this child. And that was for significant access with this child.
Right, look, your client is a commendable person, there's no doubt about it. He's willing to pay child support for a child who's not his biological child. We don't see that. Most people we see are trying to get out of paying support. He's trying, he wants visitation. I mean, I know he wants custody, but he sounds like he's willing to take visitation and the financial obligations that go along with it.
Absolutely.
However, he's got a significant hurdle to overcome, and he spent time with the children, he cared for the child, he was a very caring individual, but we have a lot of child care providers who have spent more time with a child than your client with this child. And, this would open the door to all sorts of possibilities for non-biological, non-relatives to step in.
And Judge, I appreciate that argument, and it's obviously one that we combated at the trial court level. But to that point, we did, in our brief, submit 2 separate tests, both of which were one was formulated by Judge Park, but the other one was Wisconsin's approach to answer your specific question. There should be a test. There absolutely should be a test. This shouldn't be open-ended. However, at the same time, we have to couple that with the Court of Appeals saying that this needs to be a fact-by-fact basis to be decided on a different case. Every case is different. We can't have a cookie-cutter test.
So doesn't it come down to that you'll need to show some exceptional circumstances to be let in the door?
Well, Judge, that was the fallback argument that we made at the trial court level through Bennett v. Jeffries, that my client did show extraordinary circumstances. And if your honors are unwilling to believe that he is standing under Section 70 of the DRL, then yes, it would be my argument that he has shown extraordinary circumstances for all of the same reasons that we argue that he is standing under Section 70.
Most of those Bennett v. Jeffrey cases, extraordinary circumstances, are the parent is unable to care for the child, him or herself, for a period of time. Usually it goes with the grandparents. I can't handle him, I gotta go to drug treatment, or I gotta work. The mother maintained continuous custody and care of the child, I believe, throughout this time period. Is that not correct?
Judge, that is absolutely correct.
And so this is, and I'm not saying it's precluded, but most of the extraordinary circumstances, we don't have that. Somebody's unable to care for the child. The other person steps in. We don't have that here.
And Judge, that's absolutely correct. We don't have that here. However, we do have here a very novel issue that has not been fleshed out by the courts. This is relatively new. It's a landscape that hasn't been mapped yet. And the Court of Appeals has not done any of the appellate divisions any favors in giving a roadmap on where to go. So unfortunately, that is up to you, but it couldn't be in more capable hands. As far as the extraordinary circumstances argument, I know that one of the issues and roadblocks to that would be the Tamika case that this case decided in 2019, where this court held that there can't be a tri-custodial situation. Now, that bleeds a little bit into the second thing that I wanted to talk about, which is the acknowledgement of paternity issue, which I believe is a novel issue as far as this type of problem.
But if we find that you don't have standing or that there aren't exceptional circumstances, we don't get there, do we?
No, Judge, I'm not arguing that you get there, but it is a novel issue nonetheless. As far as the Tamika case, this case couldn't be more different from that case. Not only was there an order of affiliation issued in Tamika that nobody disputed, but 4 years had elapsed between the time of the order of affiliation being entered and when the non-biological mother in that case brought her petition for custody. Also notable is that in that case, the non-biological mother, did not raise the extraordinary circumstances argument at the trial court level where we did here. And so, Judge, for those reasons alone, I believe that Tamika is distinguishable. But it really gets me to the second argument, which is on the acknowledgement of paternity. The record is fleshed out with, on May 14th of 2020, the mother testified under oath that the acknowledgement of paternity that was submitted to the court as a proposed exhibit listed a purported father that was not, in fact, the biological father of this child. Not only was it not the biological father of the child, but the mother testified to who the actual biological father of the child was, and that she knew that prior to signing this acknowledgement of paternity. Now, Judge, after hearing that, I, on behalf of my client, filed a motion seeking for it to be set aside, knowing full well that my client does not have any legal authority to do so. He wasn't a party to the document, and it had been more than 60 days. However, I did ask in that motion for the court to set it aside sua sponte, and had hoped that the child's attorney, knowing that she's directly influenced by this acknowledgement, would seek to have it overturned as well. Neither of those two things happened. And not only did neither of those two things happen, but the acknowledgement of paternity was entered into evidence over my objection, which is interesting as it is a fraudulent document. Now, Judge, this has wild ramifications above this case. We have a public policy problem that an acknowledgement of paternity was used as an end around to an adoption proceeding.
The Supreme Court didn't put any weight on that, did they? And my reading of their decision, which I can't tell you that I remember every word, but I don't think that they gave any weight to the later acknowledgement.
Judge, that's absolutely correct. I don't believe that Judge Ferletto gave any weight to the acknowledgement. But the fact remains that it was admitted into evidence and is part of the court's record, and our contention is a fraudulent document. And our concern really is that this was used as an end around of an adoption proceeding. No background check, no court papers, no attorney's fees, no home study, no surrogate court or family court involvement. And it really is a slippery slope that we had a court learn this and not set it aside. But more importantly, Judge...
Counsel, I'm just going to say you should be mindful of your time.
Yes, Judge,
You're
I will.
You're getting close to your time.
Thank you, Judge. And if there's no other questions, I will rest on my papers.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Camille Brown, attorney for the child. The court below, after the full and complete hearing on the threshold issue, found that the appellant did not have standing to seek custody or access. It's my position that the case law simply doesn't support his position. To the extent that I previously argued on behalf of my client that access was appropriate, my client's position has changed on appeal, and the court should take into account her current circumstances and development. The child continues to reside with her biological mother.
Your client
and her
is
legal
5 years
father.
old now?
That's correct, Judge. The child's express wishes have changed, and she no longer identifies the appellant as a father figure and is no longer seeking access with him. As evidenced by my withdrawal of my notice of appeal back in April 2021, I do not support the appellant's position nor him having any access with the child. With regard to the remaining issues, it's my position that the trial court properly denied appellant's motion to set aside that acknowledgement of paternity. The appellant actually stipulated to that acknowledgement of paternity and birth certificate into evidence during pretrial proceedings. Later, the court properly declined to withdraw them from evidence and to vacate them. To the extent that the appellant argues for the first time on appeal that the child received ineffective assistance of counsel, I don't believe that That argument is preserved for your review here, but if it were, assuming that it were preserved, it's not in a child's interest to have her legal father, with whom she lives in an intact family unit, removed from an acknowledgement of paternity. It's in her interest to have two parents who are financially, emotionally, and otherwise responsible for her, instead of one. For those reasons, I'm asking this court to affirm the finding of the lower court and rest on my papers. Thank you for your time.
(949) Antoinette C. versus the County of Erie.
Good morning, Your Honors.
Good morning.
May it please the court, Tom Navarro for the County of Erie. There's several issues that are in my brief, but the key issue here, I believe, is the actual notice, but in this case, lack of actual notice. Your Honors, yes, the deputy and the New York State trooper knew about this accident and the slushy road, but one important thing that is needed to have actual notice of the essential facts constituting the claim is some connection between the accident and the county's potential liability.
Don't the claimants concede that there was no actual notice by the county?
I'm sorry?
Don't the claimants concede that there was no actual notice by the county?
Exactly, and the judge agreed. However, it was argued by claimant that we had actual notice. But
There's
they
no,
did concede on-
and I think there's really no question that there was no reasonable excuse for the delay.
Okay.
So it seems that the trial court decided this case based on the lack of prejudice.
Yes, on
And
substantial.
from our perspective, the question is whether that was an abuse of discretion, right?
Okay, yes, and I.
Or an improvident exercise of the court's
Yes, and I
discretion.
appreciate that. And the burden, as in the Newberg case, or the burden initially rests on the claimant to show that a late notice claim would not substantially prejudice us, but before it switches to the County of Erie. However, I don't believe that burden has shifted. I believe that not being able to inspect the automobile substantially prejudiced us, because the lower court actually in their...
Yeah, the lower court acknowledged that it was some prejudice.
Some prejudice, yes, Your Honor.
But it didn't overcome what they ultimately decided. It seems to be that it's one factor that the court really, we've got to decide whether lack of prejudice alone, when there's a little bit, you know, the car not being there, is that enough under the case law and under the standard that we have to review?
Yes, no, exactly, and I believe that's substantial in inspecting a car, inspecting the brakes, inspecting the tires, getting a meaningful, obtaining a meaningful and thorough inspection. And the car, who says the car is there? And in the record, isn't it the claimant's burden to provide something in the records of the car, that yes, the car is there, you have opportunity to inspect it. It's not our burden, it's their burden. Just like the reasonable excuse.
Let me ask you this. I mean, a lot of the transitory conditions cases, there's going to be no prejudice if you look at if notice had been given on the 89th day, as opposed to the date it was eventually given.
Yes, Your Honor.
We're looking at the added prejudice from that period, not from day one, because a lot of the ice and snow and things along those lines are going to be wiped away by the 89th day,
True.
the 80th day. But it seems to me that the biggest hurdle you have to get over is the wide discretion, the standard of review. We have these cases where we seem to give extreme deference to the trial court, such that we could have a case where we would affirm it either way. If the trial court granted the motion, we would say that's within the discretion of the trial court. On the other hand, had denied the motion, we would affirm it. That seems to be the biggest obstacle to you here. Are we going to say, it's not what I would have done here. That's not the question of what we would have done de novo. Getting over that wide discretionary standard of review.
And I understand that, and I think your point, Your Honor, is a transient condition, correct?
Yeah,
Okay.
one of the points. Yeah.
Okay, one of your points, but would it be ridiculous to think because the snow and ice is a transitory in nature, it should weigh against the claimant? Because there's cases out there, perhaps not snow and ice, but liquid on steps. There's the case, the Harris case, where the court stated in the Harris case, the defendant's prompt investigation rights are not restricted to minute examination of the transitory condition, since the essence of the claim is defendant's breach of duty of care, that they were prejudicial by delay of the opportunity to search for witnesses.
Well, that's the point. I mean, the transitory nature of the condition, particularly in snow and ice cases, may change the next day. It may change on day 1 or day 2.
Yes.
And certainly will likely be changed on day 91. But I think your argument is that the prejudice really relates to the opportunity to meet with witnesses, to locate them, to locate the car. But the question I have is, I don't see anything in your papers that shows that you, that, for example, the car is unavailable for inspection, or that these witnesses can't be found.
And I understand that, but why is it?
You say it's not your burden.
Yes,
I'm not
exactly.
so sure
Why
I
is it
agree
our
with that.
burden?
If we don't agree with you and the ball is hit over to your side, in other words, they scratch the surface, and now it's your burden, I guess the point is, do you have a problem? In other words, we don't know if you had, the car was available, did you have a chance to look at the brakes, the tires, that kind of thing?
Yes, but I believe and I contend that it's their burden to supply it in the record.
Yeah, I think I understand that.
Okay,
To establish the absence of prejudice.
exactly.
Okay, I think we got it.
Thank you.
Thank you.
Good morning, Your Honors. May it please the court. Jesse Drum of the law firm of Brown Chiari for the respondent appellant. Claimant respondent. Your Honors, we're focused on the lack of substantial prejudice, so I will begin with that. Here, the county, in their opposing papers to the initial order to show cause, requesting leave to file a late notice of claim, submitted 0 exhibits, 0 evidence.
So their argument is that it's your obligation to establish the absence of prejudice before they have to make a showing that there is prejudice. How do you respond to that?
So our burden is to show that there is a plausible argument that there was no substantial prejudice, and that is in the matter of Newcomb case, which was conspicuously absent from the appellant's papers, the 2016
And your
Court of
point is
Appeals
that's a
case.
pretty low bar.
Yes, right. And we think we've met that bar by basically saying, what is the difference in their investigative abilities between day 89 and which would be February 14th, 2019, and when we submitted the order to show cause on September 4th, 2020. That what might they have gained during that time period?
Yeah, in other words, the points that Justice Lindley made.
Exactly.
And maybe others, I don't
Right.
remember.
Right. And so we
And
believe
so
that.
you're saying once the ball went over, you hit the ball over, and then they had to come forward with witnesses that are unavailable, or the lack of the ability to see, check the car out, see if it was
Right.
the tires or the brakes.
Exactly.
Okay, so let me ask you just a more fundamental question. Is that enough, that one factor, does that get you there?
I believe it does, Your Honor.
Do you have a case that's just one factor?
Yes, there are 2 cases that focus strictly on the transitory condition. First is matter of Shumway, and that is cited on page 19 of my brief. Matter of Shumway versus Town of Hempstead. And the court said, second department case, the court said, here the petitioner presented a plausible argument that the late notice will not substantially prejudice the town because the alleged icy condition was highly transitory such that the town would have been in the same position regarding any investigation, even if the notice of claim had been timely served. And that is exactly our situation.
Was there, in that case, was there no reasonable excuse and no actual knowledge as well? In other words, was that a prejudice-only case, lack of prejudice only?
I'm not sure, Your Honor, based on my...
Are you conceding that there was no actual notice here?
No, Your Honor.
You did below, though.
We conceded that no formal notice of the claim was submitted to the defense, and that if they say there wasn't notice, that they never received a notification of this claim, then so be it.
Has your position changed from trial level to appeal on that issue?
In a way. I mean, we're basically saying that the police report that they submitted, or that they authored, that their deputy authored, provides actual notice, and there's a case directly on point with that, that they also failed to cite, and that's another seminal case on this issue. That's the Zeiker versus Town of Orchard Park case.
You're not saying this is a lack of prejudice case only?
I don't believe so, Your Honor.
You say you got 2 out of the 3 main factors. We know it's not exhaustive. There's plenty of others that nobody ever talks about. I'm not sure where they are, but of the 3, you claiming you got 2 of them.
Right.
Okay, tell us how you have the other one. In other words, you're saying that you do have actual knowledge of the essential facts constituting the claim?
Yes. We believe that they received actual notice of what they needed to get actual notice, which under the case law is essentially constructive notice. They call it actual notice, but I read that as being a notice of claim. But what the cases say is that a police report, if it makes some connection between the defect or the negligence and the injury, that can form actual notice.
And when did this take place?
Sorry, what?
When did this take place?
This accident?
No. What is your argument again when they had receipt of that police report?
Well, when it was signed by the sheriff, it was issued or signed by the investigating officer and then co-signed by a supervisor.
So they were the agent for the county?
Yes.
The sheriff's the agent for the county? That's your argument?
In this situation, yes, and that's consistent with the cases where the town officer was an agent of the town.
Doesn't that go against our case law? You know, the county, the sheriff is its own constitutionally, it's a different, we've decided that many times, that that's a separate entity than the county.
I'm not aware of that case law, Your Honor, but that is not in the record.
Do you have another argument with that? In other words, that they were in receipt of that document within, what's the statute say, 90 days?
Right.
Or within a reasonable time thereafter or something to that effect, right?
Right,
Do you have, on this record, was there any proof of that?
Of where it went after the county employee signed it and was co-signed by another county employee? No, we have no record evidence of where it went and who received it after that, if
When you
anybody.
say county employee, we're back to what, your position is the sheriff is a county employee.
They're the sheriff of Erie County, and if they're not an employee, they're an ostensible agent. There's been no argument made to the contrary or evidence submitted to the contrary.
Counsel, does the fact that the, let's call it the victim, or the injured party is a child, does that make any difference?
Does the age of the injured party make a difference?
Yeah.
Absolutely. It's my position in my papers that we don't even need to get to reasonable excuse, substantial prejudice, or actual notice, because as an 8-year-old, the strict requirements of the notice of claim requirement just doesn't apply as a matter of law. There's a whole line of cases that supports that.
If there's a nexus between infancy and the failure, it has to, I mean, it's just not infancy alone, like, I mean, there has to be some reason that connects the two, right?
There is a line of cases that sort of goes along with that, where infancy is used as a reasonable excuse. There's also a line of cases that say exactly that infancy, that the strict requirements of the notice of claim requirement is not to be applied against an infant as a matter of law. And that is where they make the distinction between an infant of younger than 10 years old, which Mr. Cummins was. He was 8 years old at the time of the accident. And then there's an entirely different line of cases, the Zeiker case, which is from 78 or 79. It's a Fourth Department case, and it says that
Well, look, it seems like here the excuse wasn't, I think you're the parents candidly acknowledged, they didn't even think of suing until they met with a lawyer beyond the deadline. So they gave no thought. It's not like the child's age had anything to do with the failure to notice. It was the parents never even thought of it, never even realized they were going to sue until it was too late.
That is true, Your Honor, but an important thing to note is that it's the child's action. And, you know, the parent's lack of diligence or research should not be imputed onto the child. And there's a reason that children don't have to file lawsuits until 2 years after they become an adult, because they need the opportunity to do that for themselves if nobody was going to do that for them. So to forsake the 8-year-old because his parents weren't diligent or didn't meet with a lawyer soon enough or didn't do their research is sort of the whole reason that this line of cases exists, is that, you know, they are not to be punished for the lack of diligence of their guardians. And I don't even think we need to get there, because if the Zeiker court goes through a nice analysis of how General Municipal Law 50E meshes with CPLR 208, and they conclude that that where the claimant is an infant.
Well, if the notice of claim requirement doesn't apply at all to an infant, then you win.
Right. Right, and basically what Zeiker's saying is the notice of claim toll or time period does not even begin to run until they're 18 effectively.
Yeah. Okay.
And so there's basically 3 lines of cases which you know, if accepted, would obviate the need to even get into the excuse, prejudice, or notice factors. It's just, he's 8, it doesn't apply to him. And then we can get into the other factors if those theories are not accepted. But
I think we have your argument, counsel.
thank you.
Thank you. 950, 951, Quinn Jacobs versus Quinn MD.
Morning, Your Honors. John Chirundolo on behalf of the appellant in this case. This is a matter that deals with an amendment of Bill of Particulars post-note of issue. And I want to just make a couple of things clear in case they weren't clear in the papers that you have. We are not making a new theory or new claim of liability in this case. The bills in particular had question number 1, which asked us to give all the contentions of liability as against the hospital. That was answered fully and completely and accurately and gave all the theories of liability. We are not seeking to change that at all. What we are seeking to change is the answer to number 8. And number 8 asked that we provide all of the names of the people for which the hospital is to be held vicariously responsible. And that's an issue that arose at or about the time of motions for summary judgment. Shortly after the note of issue was filed, the defense hospital made a motion for summary judgment. We made a cross motion for summary judgment. And the court below denied both motions, but in doing so alerted us to the fact that he did not believe that we would be able to prove anything concerning the 5 names that we were trying to add to the bills of particulars, which saw our client during the 28 hours that transpired after the initial surgery. And I think the facts are a little bit important in this case, not only a little bit, but a lot important in this case, because this is a lady who went in for neck surgery. The surgery was done by defendant Moquin. The hospital was told by orders by Dr. Moquin to contact him should they see anything happening that raises the issue of a neurological event. She immediately, after the surgery, within the first hour, had started to have neurological issues, first with the right hand, then with the left hand. then with both arms, eventually, after about 12 hours with the legs, and thereafter it took 20 hours to let the doctor know that this happened, and 8 hours later surgery was started. So she had a hematoma that was growing in the spinal canal, causing pressure on the spinal cord, eventually leading her to become quadriplegic or quadriparetic. And our contention all the way along in the bills of particulars in answer to number one is that the hospital agents or employees were negligent because they failed to do an adequate evaluation of the plaintiff. They failed to report signs and symptoms that were necessary to report it to the doctor. And that they, during that 28 hours of time, just botched it until finally they did get a hold of the doctor. And the doctor then ordered an MRI, which he said was ordered stat, took 4 hours to get that done. And the result was a very bad result on behalf of the plaintiff. So we're not changing any of those claims. Those are not changed.
Right, you identified 3 nurses, well, 2 nurses and 1 personal assistant in the bill of particulars as the employees who the hospital will be vicariously liable for. Then, after the summary judgment, you came in with various other nurses in the PA who replaced the first one, Munson Burke. Why weren't those, it looks like the first set were treating the patient on the first day, and then the second set came in and relieved him on the second day. Why weren't they all identified in the bill of particulars to begin with?
In all honesty, Judge, what happened was we got an expert for the summary judgment motions, and the expert showed us that, in fact, the other people were liable as well during that same time period that we were contending that there were errors made.
Because they did the same exact thing, just on a different day.
Same exact thing, maybe not on a different day, because they overlap, because Munson Burke was on, then off, then back on, and the other ones were in between. So they were all during that 24-hour period that is our contention from the beginning. And the result of that is that they collectively saw, not only Munson Burke and not only Nurse Kelly, but each of them in turn saw the progression of the signs and symptoms that the plaintiff had. When it came time to get the MRI done, the MRI, instead of being done stat, took 4 hours, and that's why we named as additionally the radiologist and the head of radiology for that administrative radiology, who incidentally gave, I'm sorry, Judge.
No, it's okay. So this apparently, I'm assuming you consulted with an expert before the case was sued, and so this was apparently something that wasn't caught until you consulted with an expert in response to the summary judgment motion.
At the time of the motions for summary judgment, and that's what happened here. I mean, basically, that's what happened. We included those claims in our motion for summary judgment. 2 of the people that we seek to name actually gave affidavits in opposition to our motion for summary judgment and in support of the defendant's motion for summary judgment. And I guess that gets into the next question: what is the prejudice, if any, of the defendant here? This whole argument started 2 years ago. I mean, it's going to be 2.5 years. We got a trial date now in June of next year. And what happened along the way, COVID came in. The case was set for trial, which was a hopeful, anticipated trial date by the court below. And that had to get struck because the courts opened for a very short trial period and closed right back down. And the result of it is that this case ended up being swept around 1.5 years until next June, in June of 2022.
So in the end, we really just have to look and see if there's an abuse of discretion. You said, what's the prejudice to the defendant? We have to decide. That's among the factors we'll look at when we decide whether there was an abuse of discretion.
I have one more question before you wrap up. That's okay. I guess I'd like to know what the progression of the litigation, how it would have changed had you earlier disclosed these names to the court and to your position on counsel.
Did we disclose them as?
No, how would the litigation have changed? Would there have been more discovery? Would there have been other proceedings?
We don't believe so. And we don't think there needs to be now. I mean, of the 5 people we seek to name in response to paragraph 8, 2 already gave affidavits, so they're going to be testifying at trial anyway. 2 others are still with the hospital from Facebook and from the hospital records. And 1 is in Pennsylvania, and we delivered the address and telephone number to the defense counsel. So, and I'm you know, and they've never said we haven't been able to contact them, we haven't been able to talk to them, that they're not, you know, that they don't remember anything. I mean, they just, oh, we're prejudiced because you gave us this too late. And we say that under the law, that we believe that even though it's in the discretion of the court should allow amendments to bills of particulars to be freely given, especially in instances where there's no prejudice. And we do not believe that there is any prejudice here, particularly given the fact that we're still 8 months away from trial, and particularly given the fact that this whole discussion has been going on 1.5 years. Clearly, the defense knows where we want to go with trial. Clearly, that's going to, and that was set forth in question number 1 of the original bills of particulars. So these people are part of that 28-hour time period. Are they going to be called as witnesses? Yes. Would we like to make a claim that they were negligent as well? Yes. That's why we want to add them as responsive to paragraph number 8. So I don't know what else I can say. I don't think there's any prejudice. I think that as soon as we recognized the issue, which was just at the time that the motions were being made, we tried to rectify it. We ended up making a motion in front of the court to have that done. We ended up being denied. Then we made a motion to renew as soon as we heard that the case was off in COVID limbo. And that was denied. And that's what we've come here to you to ask you to allow us to name these 5 people under paragraph number 8 as an amended bill of particulars and go forward with the case so that our client can get a fair day in court about the whole 24 hours, because all of a sudden some of that 24 hours that we claim in paragraph number 1 is going to get cut out because of the rulings of the court below. And I think that's awfully punitive to the plaintiff under the circumstances. It's not the plaintiff's fault this happened. It's, quite frankly, it's ours.
It is a little bit of a shell game, isn't it? I mean, who was involved? It's their records. You've got to interpret their records and try to figure out.
Exactly. And that's what happened. You know, the first evaluation didn't come up with the names that we eventually found out were important names after we got an expert for the motions for summary judgment. And as soon as we got it, we tried to let the defense know. We gave them the names in the motion, and later on, we tried to amend as quickly as we could amend under the circumstances. And then as soon as we heard the trial was split off indefinitely, we moved to renew. And clearly the whole time, because 2 of the people did give affidavits at the time of the motion, so there clearly was knowledge by the defense that this was part of the case. And the issue is whether we can put the names under paragraph number 8 as being individuals who worked for and at the hospital under the employ of the hospital, and whether they should be responsive, or whether the hospital should be responsive for their acts of negligence during that 24-hour time period.
I think we got it.
Thank you.
Thank you, Susan.
Good morning, Your Honors. May it please the Court. Andrew Borelli on behalf of Krause Hospital. I'd first like to begin, before I get into the substance of the motion to amend that. In my view, I'm struggling with how the Court can get to these appeals now in light of the earlier decision on appeal from the motions for summary judgment, in which it was affirmed and upheld in part. Part of that early decision was the dismissal of these claims of vicarious liability, and now that's been affirmed. And now we're here on these subsequent motions to amend the bill of particulars and to renew to amend the bill of particulars.
Yeah, even if we were to agree with you, there is one nurse that wasn't involved in that prior decision.
You're referring, I think, Your Honor, to Nurse DiLiberto?
Yes, that's right.
Nurse DiLiberto, yes, was not mentioned by name in that prior order, but the judge's decision did say that in that same decision that the plaintiff was limited to the individuals named in the bill of particulars, which would be Nurse Kelly and P.A. Munson-Burke at this point.
No, but if you're arguing that summary judgment was right or wrong, was granted in the last proceeding, that wouldn't apply to this nurse, would it?
Well, I think it does based on the language of the decision that says that plaintiff is limited to the people named in the bill of particulars. Maybe that was not in the ordering paragraph, but I think that the language of the decision nonetheless indicates the limitations.
Yeah, I understand.
And beyond that, if we move into the merits here, the hospital's entitled to some sort of finality here. We got a decision that says that these claims are dismissed, and after summary judgment, they're making these motions to amend. They could have cross-moved to amend. Opposing counsel just indicated that their expert at the time of summary judgment alerted them to the possibility that these individuals might be negligent. But instead of also making a cross motion to amend the bill of particulars with their summary judgment motion, it was simply a cross motion for summary judgment without any attempt to amend the bill of particulars at that point.
Well, you wouldn't disagree that the prior order of the court went too far.
I'm sorry, Your Honor?
You wouldn't disagree that at least with the prior order, you're saying that that ship has sailed, but you wouldn't disagree that the court went too far with granting summary judgment. I mean, the idea was whether or not, the theory and with these individuals, whether that should be allowed.
I mean,
you wouldn't grant summary judgment to somebody that doesn't exist, right?
Yeah.
Or in favor of somebody that's not a party. You would just limit the theory as to the particular folks that were responded to in paragraph 8 or 9, whatever it was.
Yes, Your Honor, except the hospital was named. If there are employees, the hospital is a party to the case.
No, I get that.
And I think even if it's considered, preclusion, I mean, the court decided that the plaintiff was precluded from presenting evidence as to these people. And so therefore, it's our position that should stand. And on the motion to amend itself, we don't think there's special or extraordinary circumstances here. Plaintiffs have had these names of these people in the record since at least their initial bill of particulars. And they never objected to that demand in the bill of particulars. They affirmatively answered it and conducted no discovery of the hospital in terms of depositions or notices to produce with respect to these people.
So, Counselor, they didn't pursue more discovery. If we were to allow this amendment, would you pursue more discovery?
Well, Your Honor, that would be a strategy decision made after that decision came out, but it's our position we at the very least, would be somewhat prejudiced because we may have lost the opportunity now to make further summary judgment motions for these particular individuals, or on behalf of these individuals, because we made our summary judgment motion based on the initial bill of particulars. We couldn't have moved affirmatively on behalf of these other new individuals.
What would keep you from doing that now that they've disclosed? Or if we were allowed them to amend, why couldn't you make that motion now?
Well, we would be at the discretion of the trial court judge to grant for a good cause because of the time period that has run now. Okay. And so we don't know exactly, of course, what the trial court might say about the good cause as to any follow-up motions for summary judgment beyond the time period.
Well, right now, the trial court said you can't amend the bill of particulars, so we don't have that.
Concerns.
Yeah. As of yet. That would be the next concern, right?
Yes, Your Honor. And then I think then the last point I'd like to make about this is that I don't think that, I know they talked about how they made a motion to renew once the trial court had to adjourn the trial due to pandemic-related reasons. But I don't think that the adjournment of the trial is necessarily a new fact here, because, in the sense that this, at least the initial decision, which dismissed these claims, was based in part upon a line of cases that said you can't oppose an otherwise proper summary judgment motion with new theories of liability, and therefore that has nothing to do with the timing of trial.
Except it does take away the eve of trial argument, though. We just learned these names at the eve of trial. The eve of trial is now many months away. Okay?
Correct, Your Honor. I don't dispute that. The trial is in June of next year, yes, that's correct. Okay. But it remains my position that that the trial should not be considered a new factor given the basis for the trial court's initial decision on that ground. Unless Your Honors have any other questions,
Thank you.
I'll rest my papers at this
Thank
point.
you.
Thank you very much.
Thank you. 9:52, Destino versus the State of New York.
Good morning. May it please the court, Kevin Hu on behalf of the State of New York. With respect to the state's appeal, the critical issue before this court is whether the trooper's conduct rose to the level of reckless disregard. It is undisputed that the state cannot otherwise be held liable for the accident because the qualified privilege under Section 1104 of the Vehicle and Traffic Law would otherwise apply. But reckless disregard is an exacting standard. It requires the intentional disregard of a known or obvious risk.
We're aware of the standard. It seems to me that the court, much of the court's decision, including its determination of recklessness, was based on credibility determinations, particularly that of the trooper, right?
I agree with you, Your Honor.
The court did not find much of his testimony to be credible.
That is correct, Your Honor. And on appeal, the state does not contest those credibility determinations and the resulting factual findings. But notwithstanding those credibility determinations, the Court of Claims ultimately credited certain facts arising out of the trooper's testimony. And those facts are the critical facts that negate a finding of reckless disregard. And so the primary flaw in the Court of Claims analysis is that it failed to give the trooper the benefit of reaction time. Claimant's expert witness...
Sorry, the benefit of what?
Reaction time.
Right, but that presupposes that we in the trial court believe the trooper's testimony as to when the fog appeared and how much time he had to respond. The trial court, as Justice Paradatos pointed out, had a lot of reasons to question this trooper's credibility. And so we just can't now... If it went down the way the trooper said, well, then you have a much better argument. But you're asking us to accept his testimony point blank that the fog came out of nowhere. He didn't have much chance to respond. Well, that I don't think the court found that fact. I don't think the court believed that. And it's not like the court believed that he had plenty of time, that he knew this area very well, and that the fog just didn't come out of nowhere immediately before he got to this intersection. So we're left with, we have to view the facts in the least most favorable to the claimant based on the court's credibility determinations. And on those facts, it makes it a difficult, not impossible argument for you, but it makes it a more difficult argument for you.
I understand, Your Honor. And as an initial matter, the four primary areas of credibility issues and then resulting factual determinations really relate to how the trooper reacted to the fog. I don't believe that the Court of Claims made any adverse determinations or contrary factual findings as to the sequence of events and timing regarding when Trooper Pedersky encountered the fog itself. And in fact, a prominent fact in the Court of Claims recklessness analysis is that the trooper did have 2 to 3 seconds between when he encountered the fog and when he entered into the fog itself. And that timing is a critical part of the state's appeal. And it was a factual finding that the Court of Claims necessarily relied upon in propounding its own theory of recklessness. And so, based on that factual finding, that Trooper Pedersky only had 2 to 3 seconds before he entered into the fog, we then get to the issue of the reaction time. And having credited the claimant's expert testimony that there is a lag time of between 1.5 and 1.75 seconds before an individual can take action, that same finding, determination should have similarly been applied to Trooper Pedersky's conduct. And what we see is that he is really left with a window of less than 3 seconds to first react to the fog ahead of him, and then subsequently react to the severe visibility disruption that he encountered once he entered into the fog. And as to the issue of how severe the fog interrupted his vision, claimant's testimony is partially corroborative on this issue. Claimant testified that as he approached the intersection within the fog became heavier and worse. And so there was no basis in the Court of Claims' own factual findings to impute knowledge of how severe the visibility would be disrupted within the intersection just based on merely observing the fog alone.
But the trooper saw fog.
He did, Your Honor.
And he knows this intersection well. He knows he doesn't have his sirens going. And he's going above the speed limit at a high rate of speed into what he knows to be fog. Now the fog comes, it's not like it comes out of nowhere, right? It's there. And I guess your argument is that he didn't realize that it was going to be as dense as it was. Is that what you're saying?
That's correct, Your Honor. So the trooper did realize there would be some impairment, and we see from the record that he did react. The Court of Claims found that the trooper reduced his speed from 70 to 50. Now, to the extent that he misjudged the risk, to the extent that he misjudged the remedial effect of his conduct, that is a momentary lapse in judgment based on the fact that he was making split-second reactions to rapidly changing circumstances.
Which you say is not recklessness.
That's correct, Your Honor. If I could move briefly to claimant's alternative theory. So claimant suggests that the trooper can be found reckless based on his conduct irrespective of the fog. Now, this theory of recklessness fails because it fails to appreciate how fundamentally the fog changed the driving conditions within the intersection itself. The Court of Claims found that but for the fog, there would have been clear visibility from all directions of the intersection, which means that the trooper would have been able to adjust his initial decisions to speed and not make a stop based on the fact that he would have seen claimant. And similarly, claimant would have been able to see the trooper and potentially yield based on the fact that the trooper did have his emergency lights going. And so the true source of the dangerous conditions at the intersection must be traced to the fog. And therefore, the trooper's conduct must be measured in relation to the fog. And we respectfully suggest that he simply did not have enough time, based on the window of 5 seconds, further narrowed by his reaction time, to really react to how dangerous and unexpected the visibility conditions would be. And lastly, if I could briefly address claimant's cross appeal. Claimant is subject to a lower standard of culpability. It is enough that he acted negligently. And in contrast to Trooper Kadersky, who really experienced at most 5 seconds within the fog, claimant would have been driving within the fog for at least 3 minutes. And that would have been more than enough time for him to appreciate the dangerous conditions, especially when he recognized that the fog was becoming more and more heavy, and really react to those circumstances.
He had the right of way, and he was going below the speed limit, well below the speed limit.
He was, Your Honor, but based on how severe the visibility reduction was, the Court of Claims reasonably concluded that a reasonable person could and should have done more. And that is the circumstance here. So unless there are any further questions, I'll brief.
Thank you.
Good morning, Your Honors. Please
Morning.
support John Collins for the claimant Francis Destino. As the court already alluded to on this appeal, it must view the record in the light most favorable to sustain the judgment.
Yeah, and the standard is under Thorson, the idea that it should only be set aside if the conclusions aren't supported by a fair interpretation of the evidence, especially when the trial court's findings rest largely on credibility determinations.
Correct.
And Justice Lindman's point must be, and to your point now, must be viewed in the most favorable light to your client.
That's right. In terms of the state's liability. And the court's credibility findings were crucial to this case. And I think on this record, even in the absence of having viewed the trooper testify live, which is why credibility determinations are accorded such deference, even on the written record, I mean, it's just, I would say, remarkable how different the trooper testified and how inconsistent his testimony was, not only with his immediate post-accident statements, where he says that it was foggy at the time of the call and he drove at a substantially reduced speed, slowed or stopped at the intersection until it looked like it was clear, and only then proceeded. At the trial, nor did he in any of those post-accident statements allude to the presence of a second vehicle. At trial, he said he was driving at 70 miles an hour in the minute and a half that he was approaching the intersection, that he suddenly encountered dense fog only 100 to 125 feet from the intersection, and that he slammed on the brakes and came to a stop in the intersection prior to the impact. And he also came up with this testimony about a second vehicle, and he said, well, there was one coming from the right on Route 93. If that hadn't been there, I could have successfully, gone through and was struck only because I stopped to avoid a collision with the second vehicle. Never mentioned that in his report. The trial court had multiple reasons to find that his testimony was credible. And in rejecting that, under the falsus in uno theory, which I think applies to a trier of fact, whether it be a jury or a bench trial judge, can reject some of the testimony or accept others. Here, the court credited the post-accident statement of the trooper, where he acknowledged it was foggy at the time, and but he credited also the testimony that he was driving at 70 miles an hour until about 120 feet ahead of the intersection when he slowed to 50 or 60. And according to our expert witness, whom the trial court credited, at that point, at that speed, even slamming on the brakes, it simply would have been impossible for a car to stop before entering the intersection.
There were no skid marks.
And he left no skid marks.
Whereas your client did leave skid marks.
That's right. And the state in its brief at pages 19, or rather 20 through 21, states that although Trooper Pazderski was aware upon entering the fog that he was only 100 to 25 feet from the intersection, at the speed he was already traveling, that was an insufficient distance to come to a safe enough speed. So rather than being exculpatory, as the state seems to believe, I think that is, basically an acknowledgement that he was, regardless of the fog, approaching the intersection at such a speed that whatever obstruction might have been, whether it be a vehicle stopped at the stop sign, an oncoming traffic, a pedestrian or a bicyclist, he simply could not have come to a stop before moving into the intersection. And I think that establishes that Section 1104, the reckless disregard standard, was met because he did not slow down as may be necessary for safe operation. And that would have been true even without fog. But the fog, as the trial court found, was a critical factor here in establishing the liability, because it credited the trooper's statement to his sergeant that, yeah, I knew there was fog and I reduced my speed, but rejected his contention that he reduced it substantially, and found that the fact that he was speeding at such, to such an extent, combined with everything else, just established that the reckless disregard standard had been met. On plaintiff's cross appeal, the trial court apportioned
25%.
25%, and I submit that was an error, and that on this record there should have been an apportionment of 0%, but certainly not 25%. In making that finding and determination, the trial court stated in his written decision that the speed limit was 45, and that Mr. Destino was had only slowed to 35 or 40 miles per hour. In fact, it's undisputed that he was on a 55-mile-per-hour road. Thus, he had slowed down 15 to 20 miles per hour due to the fog. It's undisputed that he was driving with his headlights on, and he, at that intersection, did not have any traffic signal or stop sign. Therefore, he had the right of way and was entitled to assume that other drivers would yield. He didn't see the flashing lights from the trooper until 2 seconds before the impact, when the trooper was about 15 yards away to his right. At that point, he did the only two things he could do: slam on his brakes and steer to the right, because the trooper was coming in front of him, and going to the right would have given him the best chance of avoiding him. He struck the rear end of the trooper's car. When a person, this court has repeatedly held, when a motorist has only a few seconds to react to someone who fails to yield, there's simply, as a matter of law, no negligence. And I submit here, the trial court, notwithstanding that this court has to view the record on that point in the light most favorable to the state, that there is simply no view of the evidence that supports that 25% apportionment.
Thank you.
Thank you.
953, Degenfelder versus Williamsville Suburban. Looks like you're alone, Mr. Hudson.
All right. May it please the court?
So we received the letter indicating that Collida has been dismissed on summary judgment.
That was the point I was just going to raise with Your Honor, so that resolves the one portion of the appeal.
Well, kind of, it's a kind of an interesting question. So 2 out of the 3 defendants signed the stipulation to allow you to amend, but Collida did not.
Correct, Your Honor.
It seems to me that there are 2 ways you can get an amendment. You either get the stipulation of all the parties, or you make a motion to the court. And this is, of course, when you need to seek leave. Or you make a motion to the court. The motion was granted. I don't know that you can parse out the stipulation and say it applies to 2 of the 3 parties based on the language of the statute.
Well, we've
But in
argued,
any event, the court
Yeah.
granted it, and so the question is whether that was an abuse of discretion. You, of course, say it was not.
that's right, Your Honor. And on the first point, under 3025, I would say that even if it's not dispositive, if you have a partial stipulation, I would submit that it's certainly an admission of a party, and it's dispositive as to that party, which is the only party remaining. And with regard to the...
It's kind of hard for them to argue abuse of discretion when they agreed to it in the first place, so.
I believe that's our point, Your Honor. And the other factors, it's freely granted, it's abuse of discretion standard. There's no prejudice here. And though we didn't have to show merit, we have an affidavit from a physician linking up the causation.
Great. Thank you.
Thank you.
Land Co. H&L Inc. versus 377 Main Realty Inc.
Good afternoon. May it please the court. Philip Oswald on behalf of the appellants. Your Honors, I'd like to start with the motion to amend to add some claims against Ms. Elena Fu, who is a corporate officer of the defendant 377 Main Realty, being kind of dragged into this in an individual capacity on what we would contend are specious claims at best. In particular, I want to start with the conspiracy to commit conversion.
Well, all right, so let me just stop you right there. When you say they're specious claims at best, in terms of amendment, the bar's pretty low. Really, the question I have is whether there's any possible interest in the real property that Fu could assert as an individual.
Sure, Your Honor.
If there is, it seems to me that amendment should be permitted, but if there isn't, then, that's what I would like to hear from you.
Sure, Your Honor. So with respect to the I guess, quiet title claim against Ms. Fu as an individual, it is a liberal standard, admittedly, but if the claim fails as a matter of law, then it is an abuse of discretion and reversible error to allow the amendment. With respect to the quiet title claim, Your Honor, Ms. Fu is an individual. Now, the case law that we'd cited said that even complete ownership of stock in a single individual does not transform what is corporate property into personal property. The title, the deed that's referenced in the complaint clearly establishes that it was 377 Main that paid $2 million for the property and took title in its name. There's been no indication, there's no indication in the amended complaint, there's no indication anywhere in the record that Ms. Fu as an individual has tried to assert an adverse claim or interest to the plaintiff's title.
And that's not her intention? Are you telling
That
me?
is not her intention, Your Honor, that's correct. We are defending 377 Maine's title. She has no claim or interest in the property as an individual. And moving back, if I may, to the conspiracy to commit
And your argument is that there's no claim she could assert. That's really the question. That
Correct, Your
there's
Honor.
no claim that she could ever assert as an individual.
Yes, Judge Paradotto, that is exactly correct. She could not assert any claim as an individual, in an individual capacity, unless there was some kind of conveyance to her from 377 Maine or the plaintiff, some type of instrument conveying an interest into her, or even purporting to, neither of which exist here.
And neither is anticipated, or?
Excuse me, Your Honor?
Can you tell us, is either of those things anticipated?
Not at all, Your Honor, not anticipated at all. Briefly, with respect to the injunction, since it's...
You do understand their concern about that, because there has been some of that kind of self-dealing here. Not with regard to your client, but, in prior or alleged misdealing.
I absolutely understand the concern, Your Honor. And if something like that were to occur into Ms. Fu individually, we certainly wouldn't appeal a decision, a trial court's order allowing them to assert such a claim against Ms. Fu. But it hasn't occurred, and we don't intend it to occur. Going back real briefly to the conspiracy to commit conversion claim, we would argue for 3 reasons that claim fails as a matter of law, or it is patently and plainly insufficient as a matter of law. First, a corporation is not property. Since at least 1918, it has been widely acknowledged that a corporation is an artificial being, an artificial person. It is not property that can be converted. And that's the first reason. The second reason is, even assuming that a corporation were property, no conversion, no interference with possession, which is the critical sine qua non, if you will, of the tort of conversion occurred here. If you look at the amended complaint, the only act alleged or allegedly attributed to Ms. Fu was somehow assisting Ms. Lee in filing what's called a biennial statement with the Secretary of State. However, filing that document, it does not even affect title, but if anything, it's some type of allegation that they are secretly claiming ownership of the corporation. That's what the substance of the biennial statement could infer. But ownership is really not relevant to the tort of conversion. It's possession. It's excluding the rightful owner from possession of the property. So assuming that the corporation could be dispossessed of itself, and it's awkward for me to even say it, that did not occur here. In fact, Ms. Liu has stated several times in an affidavit, which are admissions at this point, that she continued to exercise control over the corporation. For example, she or another corporate entity that she has total ownership of held all of the shares in the corporation. That's on page 18 of the record. She also averred that she controlled the property, which was the plaintiff's primary asset. That's on page 19 of the record. She also averred that she used the plaintiff to undertake a large renovation and repurposing project. Again, page 18 of the record. So not only can a corporation not be, is not property that can be possessed, such dispossession did not happen here. And then third, assuming that it did, it would be the shareholders who would be injured. And in fact, in the amended complaint, in 2 places, the plaintiff seems to concede this by saying that they are asserting that cause of action on behalf of its shareholders. And that's paragraphs 39 and 46 of the amended complaint on pages 192 and 193 of the record.
Yeah, I'd like to hear, I don't mean to break your stride, the issues with the preliminary injunction and notice of pendency.
Sure, Judge Gardner. So the issues there are relatively narrow. We only appealed on the injury element. And that doesn't, not necessarily meaning that we're conceding or we're not confident in the merits of our case, but admittedly, there were certain factual decisions in the other 2 elements that likely aren't reversible under the abuse of discretion
So
standard.
your argument is that that Landco is adequately protected by the notice of pendency. right?
Exactly, Your Honor.
And that there's no need therefore for a preliminary injunction.
Exactly, Your Honor. The notice of pendency, the particular terms of it here guard against the exact identical risk or the terms of the injunction guard
Then
against
why
the.
do you care if both of them are granted, or both of them are in place?
Well, Judge, because if it's only the notice of pendency, my client has several private investors, the property's in disrepair, money is needed.
That's the whole
exactly
point.
it. That's the whole reason why they need an injunction. Their two are not the same. The injunction will prevent all these things that are being done to the property, leasing it out, getting tenants, getting rents. The injunction is broader than Liz Pendens. Would you agree with that? That's why you're here fighting it. The injunction is going to prevent your client from doing things that the other side doesn't want them to do.
Correct, Your Honor. That's true.
So they're not one and the same.
Well, Your Honor, the risk that they guard against, the risk of injury are one of the same.
Yeah, your argument, as I understand it, you're saying that the preliminary injunction shouldn't be granted or should not have been granted because the notice of pendency abrogates any threat of irreparable injury. In other words, any actual harm.
That's exactly correct. So the harm that the notice of pendency is geared toward, and this is kind of reinforced by the plaintiff's brief, is that somebody might acquire some type of adverse claim or interest that might encumber their title. However, a notice of pendency exists to protect against just that.
But, so with respect to the preliminary injunction, though, they want the protection of the preliminary injunction to protect other things, to protect other conduct. Your client is in possession of property that they say is theirs. They want to protect what they say is a $20 million or so that they've invested in the property. Without, it seems to me, without the injunction, you could demolish the building if you wanted to, right? Your client could.
Well, the injunction doesn't prevent us from demolishing the building, Your Honor. With
Well,
the injunction in
how about this
place,
then? How about this? Then? It prevents you from selling the property.
prevents us from leasing, encumbering, or otherwise, I can't remember
Hypothecating.
Exactly, Your Honor. Sorry, thank you for
Yeah.
helping me out.
So I guess that's the question we've got to answer.
Correct, Your Honor.
Whether or not.
In fact, there's a stipulation in place.
But you agree that the court does have the discretion to do both, but just in this particular case, because the one prong, the prong of
Irreparable
threat
injury.
of irreparable injury, actual harm, can't be met.
Exactly, Your Honor.
You're not arguing that it can never be done. You know, court could never have the discretion that after a notice of pendency was filed, that they can't also, in addition, grant a preliminary injunction, just not in this case.
No, absolutely not, Your
Okay.
Honor. I think the risks that both guard against are exactly the same, and then therefore, there's no irreparable injury.
Do you dispute, now I know this goes to the merits and it's irrelevant to the issue you're just talking about, but I'm just curious, do you dispute that Lee lacked authority in February 2020 to transfer the property to 377 Main Street? She had already transferred her shares, the shares to Lou. So do you agree with their allegation that Lee, that was a improper transfer? You can't transfer that which you don't own?
Your Honor, I would agree that based on the record and based on the very limited discovery, that appears to be true at this point, Your Honor.
So there was a sham transfer to your client. Your client got the property from somebody who didn't own it.
Yes, but my client paid $2 million for the property.
Pretty good deal at the time.
Correct.
It was a pretty good deal, wasn't it?
Well, she is entitled to the benefit of the bargain, Your Honor. It is a property that's in extreme disrepair. $2
Looks like
million.
it was almost like a self-help. I don't know what was going on between these other two folks, but the money that she was owed is the exact amount she sold it for.
That appears to be what occurred, Judge,
Right.
to me as
I mean,
well,
I
Your
don't,
Honor.
you know, probably not fair for me to say it's speculation, but that's.
Correct, Your Honor. But to the extent that it wasn't made clear in the brief, we wholeheartedly dispute that we had any type of knowledge of the back infighting between Ms. Liu and Lily about the share transfer agreement or any of that. We hired a title agent, got title insurance, did as much diligence as you could do with respect to whether Lily had corporate authority to execute the deed. But being, I'm sure, at the end of my time, Your Honor, I'll close up very quickly. But simply, there was no risk here that a $35 notice of pendency could not protect against. And there was no property that was converted. There was never any dispossession, and if there was, only the shareholders were harmed. So please reverse. Thank you.
Thank you.
Good afternoon.
Good afternoon, Mr. Grimm.
Richard Grimm for the respondent, Landco, and I'll talk first with respect to the notice of pendency and
The preliminary
injunction. So in this case where there are clearly allegations, suspicions, and now, to my mind, confirmed suspicions that there has been fraud, that there's been, that Lily and Elena Fu, the principal of 377 Main Realty, have acted in concert. Landco needs that extra protection of the preliminary injunction on top of the notice of pendency.
Yeah, and it's really a discretionary call by the court, right? And
Yes,
so
Your Honor.
You've got that going for you.
Right, and I think the court got it right. I mean, I think, you know, what we knew back in February of 2020 has not only been bolstered, but kind of confirmed by what we learned with respect to that transaction down in the Catskills. Again, there's another transaction involving the same parties, the same lender, the same title company, similar circumstances.
You argued in your brief that, you know, maybe some lessee might come in and not do their due diligence, like you would if you were purchasing a piece of property.
Correct. So the notice.
In other words, they wouldn't see the notice of pendency.
Right. The notice of pendency and the preliminary injunction are kind of directed to different parties. The notice of pendency says to prospective purchasers, lenders, third parties, hey, you know, look out, be aware, there's a problem here, or a potential problem here. The preliminary injunction says to the owner, hey, don't do those types of things that you may contemplate doing, because it's going to take an already complicated case and further complicate it by making it one step further attenuated. So that's really why we need the protection of both of those instruments,
Can I
both
ask
those
you,
provisional remedies.
can I ask you about the proposed amendment?
Yes.
What possible interest in the real property could Fu, as an individual, have?
At this point, I don't know. We know that there's been these allegations of fraud. There's been an allegation that Elena Fu has acted as a straw man or a straw person, in this case, on behalf of Lily. We know that there's case law, that Pillar versus Princeton case, that says that a member of an LLC may be a proper party with respect to an Article 15 claim.
Yeah, you know, the hard time I have with that principle is that Fu can't pierce her own corporate veil. You don't disagree with that?
I don't.
Right? Yeah.
I don't.
So, I guess I'm caught up with this, you know, when I started digesting all this, I went back to look at the statute and whether the may talked about whether a claim or an interest in real property. And I think that may have an interest in the real property. I can't imagine any interest under any theory that she would have. But even if we were to say that that amendment should not be allowed, I guess if it was, as long as we made it clear that you know, you're not stuck with that just in case something comes down the pike.
Right.
Where Fu comes up with some theory that you can't come up with right now. And to be perfectly frank with you, I can't imagine. Maybe there is one that I don't know about.
And if Elena Fu is not a proper party to the real property, the RPAPL Article 15 claim, we still believe that she's a proper defendant, because we still believe that there's a viable tort claim against her. And I will concede to the court that we struggled with what the tort ought to be, but we know that there are allegations that she acted in concert with Lily to deprive the property owner, Landco in this case, of the property at M&A's building. We know there are now allegations that she acted in concert with Lily to transfer property that, in defiance of a court order with respect to that New York County court order in the prior Tuck case. So we're struggling with, I will concede, with exactly what the tort is. But I think in a notice pleading state, where there are allegations of this sort of conduct, that we've stated a viable claim for aiding and abetting. And maybe we didn't properly characterize it as an aiding and abetting claim. But I think the facts, I think the allegations are included in the amended complaint.
You described it as a conspiracy to commit conversion, right?
We did.
Yeah.
It may not be. I'll concede that. It may be an aiding and abetting claim. But the
Well, then that may be for a later date.
yeah, exactly, and a motion to dismiss or a summary judgment. Again, we're still at that 3025B, the amendment stage here. Okay, unless there are questions, I'll
Thank you.
conclude. Thank you, Your Honor.